Supreme Court of the State of Washington is now in session.
Good morning and welcome to the Washington State Supreme Court. Today is Thursday, October 29th, and the court is hearing oral argument this morning by video conference. The first case of the morning is Brian Green versus Pierce County. We have Daniel Hamilton opening for 16 minutes, and then Joseph Thomas has 20 minutes for response, and Mr. Hamilton has reserved 4 minutes for rebuttal. Mr. Hamilton, you may proceed, and I'll remind you to unmute your audio.
Thank you, Your Honor. Again, my name is Dan Hamilton. I represent Pierce County, and good morning. The history of this is that after the legislature learned that persons connected to the murder of 4 Lakewood policemen had made a Public Record Act request for personnel records, our legislature enacted what is now RCW 42.56.250 to protect against Public Record Act disclosure of photographs and birth dates of police. Now, the legislature protected these 2 types of records because, as this court recently recognized in Washington Public Employees Association, quote, disclosing birth dates with corresponding employee names may allow Public Record Act requesters or others to obtain residential addresses and to potentially access financial information, retirement accounts, healthcare records, or other employee records, end quote, and thus expose police and their families to potential physical harm and harassment, as well as identity theft and fraud. But because reporters use this kind of data as a means to discover newsworthy information by matching up public officials with their databases of criminal convictions, cases, and arrests, the legislature provided a narrow exception that only, quote, news media as defined in RCW 5.68.010 sub 5, which is the SHIELD law, shall have access to the photographs and full date of birth. Now, recognizing that public employees are also at risk by unprotected general public access to this data, this year, the legislature expanded the statute to protect them as well. Now, in this case, the briefs are undisputed that the photographs and birth dates at issue are protected from the Public Records Act disclosure by 258 unless Mr. Green had met the statutory news media exception to that protection. Thus, there are 2 main legal issues. Did Mr. Green show that he met the statutory news media exception? And if he did, should the county have been allowed discovery to explore if that is true? Though the legislature this year expanded the statute, it is undisputed its intended protections would be judicially nullified if the trial court's decision was affirmed, because disclosure of the protected information would be the rule and not the exception if requesters are deemed news media so long as they have a social media account, which is 80% of the population.
Let me ask you.
Yes.
Let me ask you about the what I see as the 2 bases for your argument. One is that the requester was not an entity because he was an individual, and the other is that he was not engaged in the business of news gathering. And I found a lot of focus in the briefs on the entity question. I was a solo practitioner as a lawyer before I joined the Supreme Court. And as a solo at the beginning, I had no employees and, just using the computer and doing everything myself. But I was certainly doing good legal work. Now I didn't have a corporate form, so I didn't file tax returns in the name of the business. It was just a doing business as. But I have a hard time saying that neither I nor law offices of Cheryl Gordon McLeod were not an entity. And I know the question of whether they're in the business of news gathering is more difficult, but isn't that really where we need to focus our energy?
I do think, Your Honor, that entity is an issue, but it's not the only issue. I would disagree with you. As the issues have parceled out here, the 2 questions are, one, the social media account. Does that meet the entity section under subpart A of the statute? As to Mr. Green, the only question is, did he meet subsection B, which also does focus on the entity issue. As far as whether, so the first one answers, also helps answer the second, but the second also has additional requirements for being engaged in the bona fide news gathering of the person. And also, just being an entity isn't enough either. As you pointed out, for instance, your law firm, I think a partnership, what the definition of an entity is, requires that it be a juridical being capable of suing and being sued. If, as the court said, Mr. Green is the social media account, then that pretty much ends the analysis, because Mr. Green is the only plaintiff here. Mr. Green was the only requester, and the social media account doesn't have the ability. That's been the reason why, is because the social media account doesn't have the ability to bring a lawsuit.
Yeah,
And
but they're one and the same. I mean, like law offices of Cheryl Gordon McLeod was exactly the same as Cheryl Gordon McLeod. If somebody wanted to sue, they would have sued me personally because I chose not to use the corporate form. So just because one is a DBA of the other doesn't mean there's no entity. Mr. Green would be the entity.
Well, Mr. Green is a person. When we look at A, when you break it down, it's very clear. Again, we need to make clear that what we're looking at is a statutory construction issue, not a decision of do we want to call things news media or not call things news media. We're talking about a privilege and a protection, and whether that privilege will evaporate unless the statute's full language is applied. So
Mr. Hamilton,
yes.
Hamilton, could an individual ever be an entity?
No, I do not believe so. And I have a lot of, and that's a matter of statutory construction, also legislative history. We can go into that, Your Honor, if you'd like me to. I do not believe, first of all, it should be a point that Mr. Green has not argued that subsection A, that he meets subsection A. He's argued that his social media account meets subsection A. But as far as Mr. Green being an entity under A, the principles of statutory construction prevent this because first, again, it would violate the interpretation of principle that we don't have absurd results, because the absurd result of this decision is that there is no privilege anymore. There is no protection of these things. In fact, as Mr. Green—
Well, there's still the requirement of being engaged in the business of news gathering, which is quite a bit to satisfy. Because your interpretation might be equally absurd if it were applied to, for example, the solo investigative person who broke the very newsworthy story about Harvey Weinstein at a point when I don't think that person was employed by anybody, and then published his own book about it.
Well, we again have to look at what the issue is. It's not that that person isn't news media in the broad sense. That person could break that story with or without this privilege, being able to overcome this privilege. And it should be pointed out too that we're not talking just about all those police officers and are we really worried about them as a legislature, unnecessarily worried that they about their finances being disclosed, but it also has an effect on the Shield statute. You can't have two bodies of law here. That interprets one for the Shield statute, which of course affects the courts and the ability to compel testimony. But so there is no absurd result. The absurd result is to negate the privilege, and that's within the statutory construction concept. What you're describing is whether that's good policy from the legislature, and of course that's not for the court to decide. The sole issue is what is the legislature's intent, and they certainly intended it to mean something. This interpretation means it'll mean very little. Now, the second issue to answer the question of—
I'm sorry,
yes.
Go ahead and complete your answer to Justice.
Thank you. I'm sorry. I was going to answer Justice Gonzalez's question about the reasons why a person can't be an entity. A second reason is legislative intent is shown by the primary author, which this court has said is an appropriate avenue to interpret the intent as well. And the U.S. Supreme Court says it's an authoritative source. But the primary author said that a person could be under a entity if they incorporate it, because the legislature needed a, quote, workable definition, so you couldn't provide a privilege to virtually anybody in the state who has a MySpace account, end quote. And that no one wanted, quote, ordinary people in their pajamas to be able to claim journalistic source protections, end quote. Now, finally, the legislative history and the statutory construction leads to that same conclusion that a person, which is in Section B, can't be an entity in Section A. And first of all, the legislative history shows that the original bill of what became .01 subsection 5A referred to any person or entity. The final version, first of all, that shows that person and entity are two different things. You don't, if they use different words, then they mean different things. That language was removed from the statute so that A now only says entity and person is only in subsection B. The enacted A, I'm sorry?
It may be that during the pandemic, some people do their best work in their pajamas, but our job is to figure out what the legislature's intent was, right?
Right, and this is, and I'm only, this is the drafter of the legislation, Your Honors, quote, I'm not making that up. And at that time, you know, I think I do some of my best work in my pajamas too. But the issue here is not pajamas or not the social media source, but this is important. This has important effects on now every governmental employee. Are people going to be able to find people's home addresses, their financial information? Are the courts going to be prohibited from or inhibited from subpoenaing people because they are, whether they're in their pajamas or in a suit, their only claim is that I come under the statute because I have a social media account and I post things that I say is news. That's essentially Mr. Green's position here, Your Honor. But just to finish that thought as to why a person can't be an entity, the subsection B category of news media is the only place where person is now described. And again, but even in that statute, that portion of statute, they include both person and entity with the concept that a person has to be, first of all, that shows that they are different words used in the same statute are presumed to have a different meaning, but they have to be an employee of an entity listed in A. So you can't both be, it's clear from the legislative language that person in B is different from a person in A. They can't, or from an entity, I'm sorry, in A, and they can't be the same.
Mr. Hamilton, I have a follow-up question to that. I don't know how familiar you are with Instagram. Do you know what a Finsta is?
What, I'm sorry?
Do you know what a Finsta is?
I'm afraid I spend too much time in my pajamas, but not doing that.
Okay, so a lot of kids have two separate Instagram pages or multiple, but one is called that's called a Finsta is the one that they allow their parents to see, that they'll connect to their parents through social media so their parents can see that. And then they have a separate one that's sort of the real one where they're posting the things that they're actually doing that they don't want their parents to see. And some of those accounts make money through advertising, clothing, and other sorts of things like that. Are you saying that that is not an entity, even though that separate Instagram account that's not for the parents is potentially making money, connecting with people around the world that they don't know? How are you separating those things?
Well, you have to look to the concept of, again, statutory interpretive principles. As the word entity is in a context in subsection A, and it deals with certain types of entities that it lists, and you get the concept of journal terms are defined by the more specific terms. So any entity that is in the regular business of is further focused by the list of publications that it and types of publishers. So yeah, someone who uses a tweet, whether it be things that can be seen, or it's not these issues concern the means of publication or the means of dispersal, of dissemination. I think that is a different part of the statutory test. So the issue is not that Facebook or YouTube can't be a means of dissemination. We're talking about entity. That's a totally different concept. If the kids using this platform meet the other requirements because they're a type of an institutional a news publishing process and meets the, in the ordinary business of news gathering and dispersal of information, then yeah, they could be an entity under subsection A. But it's not because it's not determinative on the platform or the means of disseminating this information. I hope that answers your question.
It does, and in a follow-up to that question, in a world where people are blogging and breaking stories through blogging and their own individual investigative research, how can you make a clear definition about what's news gathering and what is a hobby?
Well, that's I think one thing. The test would be the Thurston County case, which I think applies here, and I think you're focusing in on news gathering and is it bona fide news gathering? And now we're talking B, that section, though news gathering is also described in A. But to be news gathering, first of all, you can't be serving your own self-interests. As in this case, it's not news. What he was requesting was 3 years old at the time, and it had to do with him. So first, it's not news, and it isn't bona fide news because it is a matter
Mr.
of.
Hamilton, Mr. Hamilton,
I'm sorry.
We're not investigating what the purpose of the individual request was. Don't we just look to whether the entity is engaged in the business of news gathering? And isn't it prohibited to try to understand the intent of the requester in a particular request?
Not at all, Your Honor. In fact, the contrary is true, where there's an exception to an exemption. The statute expressly provides, in fact, that in certain cases, the request can be made to produce information. And that's part of the issue here too, Your Honor. And let me find that statute real quick. 4256-0802 allows and requires the public records officer to ask to provide, they can request people to provide information to establish whether inspection and copying would violate any other statute which exempts or prohibits disclosure of specific information or records. Otherwise, what you have here is what Mr. Green is arguing, which is, I think his exact quote from his brief was that Pierce County, the only way Pierce County can ever withhold this protected information, and we're not talking about all public records, we're talking about a very narrow 2 items, is by concluding that you're not a news media. And so again, Mr. Green would have the default being, even when you meet these kind of records, only 2 kinds, photographs and birth dates, then the public records officer has to make a call based on what, because nothing was really provided here, to say what they're protected. Yes.
Hamilton, I want to jump in and make sure you know you're well into your rebuttal time at this point.
I am, and I just wanted to finish. It's more important to me that I answer the court's questions. So thank you. I hope I have. I'll reserve whatever time I have left.
Okay. Thank you, Mr. Thomas. We'll turn to you and you have 20 minutes.
Thank you, and may it please the court. The issue in this is whether Respondent Brian Green and his YouTube channel, Liberty's Champion, constitute news media for the purposes of the Public Records Act under RCW 5.68.010 subsection 5 and RCW 42.56.250 subsection 8. And the issue in this appeal couldn't be timelier. In May, nationwide protests were sparked when individuals who recorded the brutal killing of George Floyd, where a police officer knelt on the man's neck for more than 18 minutes, suffocating him to death. If citizen journalists had not recorded the killing of Mr. Floyd, then the entire incident may have been swept under the rug, as citizens journalists' videos have become primary evidence of the killing by the police. In the aftermath,
let me just interrupt you there. What makes someone's a bystander taking a video with a phone that virtually everyone has a journalist?
It's the intent. We can look at the person's track record. Have they been performing this sort of activity before? How often do they do it? If somebody does this once every 5 years, I think we could agree that that person is not news media. If the person records these videos weekly and uploads them, then they have a pattern and practice of doing. Are they showing it privately? If this is only being shown privately to 20 of their friends, then they're probably not news media. If it's being disseminated to the wider public with the intent of the public generally viewing it, then I think we can agree that there's news media.
I don't
The
see the
citizen,
word, I don't see the word
go ahead.
intent. I don't see the word intent in the statute. I see the words bona fide, but the first definition of bona fide in a regular dictionary is genuine.
Thank you for that question. And I think that when, at least when respondent Brian Green is talking about intent, we're looking at the definition of bona fide, like you said, and genuine. Are his actions made in good faith? What is him? And to determine good faith or genuineness, we're looking at looking at his intent.
I
Is he
thought
doing
bona
this?
fide,
How often is he doing this?
if bona fide's meaning is genuine or real, which is the first definition in Merriam-Webster as opposed to Black's, isn't that an objective inquiry that the court gets to examine and weigh in on, as opposed to a purely subjective inquiry about intent?
Yes, Justice. But in fact, Mr. Green also says in the last response brief to amicus WSAB, WNPA, and RTDNA that he's fine with an objective test too, and actually sets forth an objective test from cause of action versus FTC, which is a federal court of appeals case. And there they decide news media for the purposes of FOIA, which is a related statute to the Public Records Act. And they set forth a 5-factor test in order to determine what is news media. And they say, first of all, they should look at the gathering of information to potential interests. And second of all, is it going to a segment of the public? And third of all, does the person use their editorials to turn raw materials into a distinct work? Fourth of all, do they distribute that work? And fifth of all, to an audience. And I think that's an objective test that could be used. And Mr. Green argues that to the court, that if the court wants to look at an objective test, it should adopt something like the cause of action versus FTC test to determine what news media is.
Mr. Hamilton seems to be arguing, if I've understood him correctly, that even if your client is an entity engaged in the business of news gathering, they may still inquire into why he wants the information and deny it if they think that there's a personal motive rather than a news gathering motive. What's your response to that assertion?
Mr. Green talks this in his briefing too. A lot of news organizations report on their own work. They report on their own lawsuits. They report on that make the news. For instance, Mr. Jeffrey Toobin made the news off a Zoom call within the last week, and his own news organizations reported on it. CNN reported on it, where he's a senior legal analyst. This happens all the time. We cite evidence. We cite the Tacoma News Tribune reporting on its own lawsuits and its own happenings within its own within its own office. This is a daily occurrence, and Pierce County just doesn't like Mr. Green because Mr. Green criticizes Pierce County in his videos because he thinks that they are hiding things from the public, that they're opaque with their dealings, and that they need to adhere to the sunshine principles of the Public Records Act. And a lot of Pierce County's arguments today are just fear-mongering.
I'm sorry, Mr. Thomas. Do you mean then to say to me that they may not look at motive? Because that's my direct question. Can they consider motive?
Yes. So to answer your question, Mr. Green in this specific instance says you can look at motive or you can look at an objective test. It's fine to set forth the argument in order to prove that Mr. Green in this instance meets either a motive test or an objective test, such as the cause of action versus FTC. Mr. Green was reporting on a legitimate news story in this instance. Police brutality, like for instance with the George Floyd murder, is a very legitimate news topic, as we've all have seen since the protest started in late May. And that's what Mr. Green was reporting on. His video of his wrongful arrest has been up on the internet. It's received hundreds of thousands of views. It's gone viral. And Mr. Green was performing more research because of Pierce County's opaqueness and their intransigence to release this information about his wrongful arrest. The charges were dropped. Nothing ever happened. He was never convicted of a crime because the Pierce County prosecutors dropped the charges, and that overreach by the police right now is a very big issue in society.
Mr. Thomas?
And I think that is a yes.
Thomas, I just want to follow up on Justice Gonzalez's question and sort of redirect you back to it in a sense that can or should a governmental agency ever ask a requester, why do you want this? What purpose are you going to use this information? It may be that there's a legitimate reason for somebody, but the question really goes back to, can a governmental entity ask, why do you want it?
So I think that's a very good question, and thank you for phrasing it that way, because I think it can happen, but I think that it needs to be done very carefully, because then the government may get into a situation where it's discriminating against speech and distinguishing amongst requesters. So for instance, in the First Amendment precludes the government from distinguishing or from discriminating against speech in a content-based way. And so if the government starts asking, what are you going to do with this? What are your motives? What specifically is driving you to do this? That may be a content-based regulation, or it may run afoul of the First Amendment. And that may raise First Amendment issues.
Can I ask
under the
follow-up to that, Mr. Thomas, which is, what is the nature
If I can just, sorry.
Is your claim a constitutional challenge to aspects of the PRA that do impose restrictions on who can request or for what purpose? For example, we have a commercial use carve out, this carve out that's at issue. Are you constitutionally challenging those aspects of the PRA?
No, not at this present time, because the statute has never been construed adversely to my client. In fact, my client won in the trial court. There is no reason in order to challenge the constitutionality of the statute at this point. We believe that if the statute is construed in accordance with the First Amendment, then, which this court is to do right now, there's no reason to challenge the statute. There's nothing in the pleadings about challenging the statute, and this is just another misrepresentation by Pierce County about Mr. Green's intentions with this law. He's merely saying with this lawsuit that he meets that news media shields. He meets that definition of news media, and so he should be able to receive his rec under the Records Act.
So
Does that answer your question?
Not exactly, because why is his interpretation based on, I guess, constitutional avoidance? You're saying this interpretation is necessary to meet the First Amendment, and I didn't see that approach being taken at all in the brief. I saw it as a definitional approach, and clearly this is more than the Public Records Act. It's the Shield statute.
Right. It is more than the Public Records Act and it is the Shield statute, but it is a statutory construction issue. And since they are on similar, they have touching upon the same issues, which is the protection of the press. Mr. Green argues that since the First Amendment protects the press expressly in the language of the First Amendment, and since the News Media Shield statute intent is to protect the press from subpoenas, Mr. Green argues that they should be construed in accordance with each other. This court should not adopt a construction of the News Media Shield statute that runs afoul of the First Amendment. And this is just a basic statutory construction argument that we're also relying upon the First Amendment. This isn't a First Amendment challenge to the statute. We're not saying that the statute is unconstitutional. There's no need to do that at this point. Was there another question?
Yes. Mr. Thomas, so I guess I'm wanting you to be more specific about what your definition of news media is, because it seems to me that the definition that you're describing interprets it so broadly that it's no longer a carve out. You're describing something that is anybody that in some form, YouTube, Facebook, whatever it is disseminating information. And that doesn't seem to be the same thing as what news channels on television are doing. So can you be specific about what it is you are asking this court to say about what news media is?
Well, I think that's a difficult question in order to answer because
But isn't it the threshold
for,
question? You have to answer it.
it is a threshold question, and I think it needs to be addressed and it needs to be answered. But it's also a very difficult question because starting to define news media can run afoul of the First Amendment, which is what we were talking about with Chief Justice Stevens. If there's a narrow definition of news media and they start, like for instance, if this court precludes procedure protections under the News Media Shield statute, then it could be a content-based restriction just because of Mr. Green's content and criticizing the government. It also is precluding his freedom of speech. The Zerilli case that's been quoted in many of the briefs says that restricting the News Media Shield statute would run afoul of the First Amendment. And so there are very strong First Amendment considerations when defining news media. And I understand your concern about, look, if this is a broadly defined, then it's going to allow a lot of people in order to claim this. I think that's when you start looking at the track record of the person and you go to that objective test in the FTC case, and the cause of action versus FTC case, where they have that 5-factor balance test. And they set forth, and I don't think that many people will be able to meet that. Then they just won't be able to wake up one morning, take a video, and then claim it. And furthermore, there is no history of abuse with the statute. The statute has been around for 13 years. And there is nothing in any of the briefs indicating that there has been even abuse of the statute. And even before the statute came around in the 1980s, this very court, the Washington Supreme Court, created the common law, created common protection for news media, and there hasn't been any abuse. And furthermore, there hasn't even been a definition of news media for the common law protection of the News Media Shield. And so I think that this court is well within past precedent and history in defining it broadly in accordance with the First Amendment. And I think that is fine. And I don't think this court should be scared by thinking about, well, is there going to be abuse when there hasn't been any documented abuse up to this point? There hasn't been any documented abuse in the 13 years since the statute has been codified, and there hasn't been any abuse and documented abuse in the years prior to that with the common law, with the common protections in Washington State.
Okay, well, let me follow up with a hypothetical, Mr. Thomas. There are a number of social media accounts that are connected. It's some individual, the individual is secret. And the idea behind the accounts is at a school or a university or something that they're asking people to send them secrets that then get published on this account. And sometimes they're, secrets about who's dating who. Other times it's information that is about spending that's going on in a department. How would this court fit that figure out whether or not that's news media? What's the difference between gossip and news media in the concept of what Mr. Green is doing?
That's a very good question, and I think the court needs to look to the audience. Is this meant for the broader public, or is this meant for, in your example, a few people in the classroom? Is this meant for somebody's friends in order to pass off as a joke or as some sort of inside story? And
well,
I think
that
the court can.
Because the intention of raising the question in terms of it being Facebook or some kind of social account is that it is not a private account. Anyone can see it. So, put it in Twitter if that makes it easier. I'm not suggesting it's something that is private and limited. I think you're right. That's a different question. Something on Twitter, anyone can see it. Anyone can find it. What's the difference between gossip and news?
Let me give you an example. So if, first of all, and the first example is that if Sally wrote on Twitter and she said that, look, Joe said this in homeroom. I can't believe he said who he was dating in homeroom, right? And that is put out to the general public under your example on a social media, whether it's Twitter or whatever else. I think that you can look to the audience then and the intent to distribute that. Was that meant to distribute it past the class, past person's friends? However, in an alternative example, if Sally said, teacher so-and-so made a discriminatory remark about one of the students, that is something that shows up on the nightly news. And so I think you need to look at this objective, this court could use this objective test to look at the evidence and who this was meant to being distributed to determine if it's news or not. If it's meant to be distributed to a wide audience, like, oh my gosh, the teacher said a discriminatory remark, that's not appropriate. That person probably intended to share it with the general public. And those are things that end up on the nightly news every day or on the front page of the newspaper. However, gossip from a classroom is not something that generally ends up on the front page of the newspaper because it's not meant to be distributed to a wider audience.
But if
Why
you're
is that not
in
a,
the same account, then then you do have the problem that I think Justice Gonzalez raised about the person who holds the information or the governmental office that holds the information having to make a decision about what the use of the information is going to be.
But I think that's also where you look at the person's track record too. Does the person have a history of doing this, like they talk about in the cause of action versus FTC case? Do they publish this? How often do they publish this? Do they do it regularly? Do they? Is this once every 5 years, like I mentioned before? And I think if you use those factors from the all 5 factors from the FTC, it provides a workable framework for the court to weigh the different situations that might arise. And this has been done in cases to determine whether people are media.
I'm sorry.
sorry.
I know it's hard on the Zoom platform. I wanted to ask a follow-up. If you're suggesting that lines can be drawn, including content-based lines under that test, what's wrong with the lines drawn in the statute? Why is it any better from a First Amendment construction point of view to do what you're describing than to do what the statute describes and draw the bright line at juridical entity?
I don't think the statute draws the line at a juridical entity, and I apologize for mispronouncing that. But when the legislature was debating the statute and when they were passing the statute, they actually they chose not to take that approach. And in the bill, let me find where it says that. So when the bill was first introduced in the House of Representatives, the bill said, a person who has been a journalist, scholar, or research employed by any institution of higher education or other individual who either A, at the time he or she obtained prepared information that it sought, was earning about to earn substantial portion of his or her livelihood by obtaining and preparing information for dissemination by any person or entity listed in any one of the subsection that goes on. So there was an economic test that would go along with this juridical entity argument, but that was taken out by the time the bill was finally passed. And so it actually says in the House Bill report, it says this definition of news media no longer includes any person who has been a journalist, scholar, researcher employed by any institution of higher education or any individual who was either at the time he or she obtained or prepared the information that is sought was earning on a professional track or earn a significant portion of her livelihood. And before Justice Gonzalez said we need to look at the legislature's intent. The legislature intended not to have for this to be a juridical, and I apologize again for that, because they took out that business test. There's no business or economic test in the Washington statute. There are in other statutes, as we briefed. And since the Washington legislature took that out, they didn't mean to anybody to have a corporate form or to be earning money by this. They could be volunteering, and then we need to look at a broad construction because the legislature intended a broad construction. Thank you.
All right, thank you, Mr. Thomas. Mr. Hamilton, we'll turn back to you, and you have 2.5 minutes for your rebuttal. You're on mute, Mr. Hamilton. I'm sorry, I forgot to remind you.
Thank you, Your Honor. I have a lot of things I'd like to respond to, but I think the most important one is refocusing what we're talking about. We're not talking about George Floyd or a video of a bystander. We're talking about a birth date. We're talking of an officer that can be used to get to their home. Now, when you become a government official, you don't sign up that people can find where you are and where your family is, and they can get your finances. The question here is, which has never been answered, there is no media news gathering here. It is about the birth dates and photographs, so that not so that they can, as the legislature intended this to be used as a means of getting newsworthy information. It is the information that he wants to put out. He wants to broadcast the birth dates directly, and he said that that's a matter of record. So that's the concern that we're talking about here. Not all types of Public Records Act requests, just a very narrow exception, and for very important reasons that this court has recognized. Now, the court has asked the question about, can they ask? The statute says 4256080 subsection 2, they have to ask. If a public records officer releases something without a good faith effort to find out if they're protected, the government can be liable. And we're only talking about asking, not what is your purpose for this, unless there is a question of an exception. That's a very narrow situation. And here, plaintiff says, essentially this statute, this protection won't exist at all unless you can, at the claims, at the request stage, prove that they're not an entity. And that is not the law. The law is under the statute that the requester has to come up with the information. This court has set in MeriQuest its own precedent that where there's an exception to protection, quote, the burden shifts to the party seeking disclosure to establish it. And also, let's not forget, we're talking about interpreting the SHIELD statute, and the court in the only case interpreting it, Republic of Kazakhstan, says the SHIELD law applies in any given situation, rests entirely upon the entity asserting the privilege. And as to juridical, Your Honor, I would bring the court's attention to just the language of point 258 itself. It says that people who meet this media, or who meet the requirements of media for this limited context, can have access to the photographs and full date of birth. Unless they're a juridical being, they can't get access to it, and they can't be sued by the individual who wants to stop them from doing it. Finally, Clampett versus Thurston County.
Mr. Hamilton, that is the end of your time.
Okay, thank you, Your Honor.
All right. Thank you, Mr. Hamilton. Thank you, Mr. Thomas. We appreciate both counsel's arguments. This case is submitted and the court will be in recess until 10 a.m.
Supreme Court is at recess.